Good evening. My name is Keith Parker. I'm Assistant Vice Chancellor for Government and Community Relations here at UCLA, and I have the honor and the pleasure of welcoming you to tonight's program and to welcome back Congressman Ted Lieu. The Congressman was elected in 2014 to serve as our congressional representative after serving from 2011 to 2014 our representative in the state Senate. We were particularly pleased to host the Congressman's local district swearing in March 1st of 2015, and if you recall, Congressman, we had a wonderful celebration that got interrupted by someone pulling a fire alarm. We had to evacuate Royce Hall, but it was a torrential downpour, and so nobody could really leave. So we had a wonderful celebration, and we were very pleased to host that. Most of all, though, I'm here on behalf of the campus to thank the Congressman for his leadership and his commitment to veterans. Congressman Lieu is the author of the recently signed into law H.R. 5936, the Los Angeles Homeless Veterans Leasing Act. This legislation authorizes the Veterans Administration to implement the master plan for the West LA VA campus. Under the terms of the legislation, the agreement Chancellor Gene Block and Secretary McDonald reached in January can now be implemented. UCLA has agreed to provide $1.5 million annually in support of new programs and services for veterans and their families. New and extended services include mental health treatment programs, family support, legal advocacy, and rehabilitative and recreational services. Even at the Jackie Robinson Stadium, we will be doing new programs that are therapeutic, that have recreational and leisure aspects to them, but also help veterans and their families. We will be building out a resilience center, and that resilience center is designed to treat the whole family, and so the veteran, their spouse or partner, their children, to provide social services, to provide healthcare services, and to provide support. And so it's UCLA's continuing commitment to support veterans and their families could only have been enabled by the leadership of Congressmember Lieu with this kind of progressive legislation that makes a difference. So again, let's give the Congressman a hand for his commitment and leadership for veterans. Tonight's discussion will be a great discussion. It will be stimulating. It will help build awareness around an important issue. It will enlighten all of us. I'd like to commend the law school for hosting this event tonight. So thank all of you and welcome to UCLA.
So, Congressman Lieu and Vice Chancellor Parker, ladies and gentlemen, I'm Sharon Dolovich. I'm on the faculty here at the UCLA School of Law, and I'm also the director of the UCLA Prison Law and Policy Program, which is co-sponsoring tonight's event. So on behalf of the law school and on behalf of the UCLA Prison Law and Policy Program, I too want to welcome you to today's important discussion on a really vital issue: how are we going to reform the broken bail system in this country? And now, as many of you know, or you will know, that the United States incarcerates more people than any other country in the world. Over the last decade or so, that number has hovered around 2.2 million people. But what you might not know is that of that 2.2 million people, almost 750,000 are held not in state and federal not in state and federal prisons, but actually municipal jails. And of that 750,000 people, almost 500,000, so 450,000, are being held under pretrial detention, which means that they are in jail even though they've yet to commit a crime or be convicted of a crime. So it'd be one thing, so we have 500,000 people who are in pretrial detention, they haven't been convicted, and it would be one thing if, well, we said, we found them to be a public safety threat, or maybe they're a flight risk, so that maybe some judge has determined that we can't actually be sure they're going to show up for trial if we let them go. But the truth is that most of the time, the reason that people are in jail pre-trial is because they're too poor to pay their bail. And this is actually a straightforward example of criminalizing poverty. If you have money, you pay your bail and you go home and you wait for your trial at home. If you have no money, you wait for your trial in jail. And I think this distinction alone would be enough to justify a really serious rethinking of the bail system that we have. But it actually gets worse. because people who are indigent or who are living paycheck to paycheck stand to lose a lot more than their freedom if they're locked up even for just a few days. So for one thing, if people can't show up to work, they're going to lose their jobs, right? And without a source of income, they can lose their cars, which, by the way, will make it harder for them to get a new job and keep it. And if they lose their jobs because they can't go to work, they could get evicted. And if a person has no job and no means of transportation and no place to live, they can even lose their kids. So this sort of downward spiral has actually been very well documented over and over again, even if people are in jail for just a short time. So what we're doing, the policy that we have, it disproportionately affects, it obviously affects poor people, but it also disproportionately affects poor African Americans and Latinos and other people of color. So basically what this means is that our current money bail policy both punishes people for being poor and it has a racially discriminatory impact. So this is all pretty bad, but it's even worse than this because recent research out of Penn Law School's Quattrone Center found two really startling things that I want to share with you. So first they found that defendants who are jailed pre-trial, right, which includes the people who they're not just found to be a flight risk or a public safety risk, but because they can't afford bail, are more likely to be convicted of the crime when it ultimately goes to trial than a similarly situated person who was able to make bail. So that's the first thing. And the second thing the Quattrone Center found was that people who had been jailed pre-trial wound up committing more crime when they eventually got out than people who were released on bail in advance of their trial. So when people are locked up pre-trial because they can't afford bail, they're more likely to be convicted of the crimes, and they're more likely to commit crimes in the future. So again, all this happens not because the person is considered a public safety threat, not because the person is considered a flight risk, but because they are poor. So I think we can say that this is a humanitarian and public policy disaster. So enter Congressman Ted Lieu with his No Money Bail Act of 2016. So this legislation is designed to eliminate the use of money bail in the federal system and to push states to eliminate their use of money bail. And we really are so grateful to you for introducing this bill and for working so hard to build a coalition to get it passed. And I'm actually also really delighted that you and your team have come to UCLA to bring us into the conversation about this issue. Now I wanted to tell you that UCLA is actually the perfect place for this conversation. As some of you will know, we have a long history of training public interest lawyers to work on behalf of people who are disadvantaged and disenfranchised. And in the United States today, as it turns out, the people who are the most disadvantaged and disenfranchised often wind up caught in the criminal justice system. So given this connection between socioeconomic disadvantage and criminal justice, and given UCLA's public interest bent, it isn't really a surprise that we have a large number of faculty and students here at the law school who are focused on criminal justice as a key site of research and advocacy and teaching and public policy work. And this strong interest actually is a reason why 2 years ago we decided to launch the UCLA program in prison law and policy, which, as I mentioned, I direct. And I think you should all have at your seats an information packet about the program. So I'll just say a few words about it here, and you might want to look at it later. We have a broad brief, as you'll see. I think on page 2 we have a program description, a program mission statement. Criminal justice reform is very much a part of what we are interested in, what we do. The program is just 2 years old, but we already have a long list of past speakers and events. And in the packet, we provided you with a couple of things. One is our fall schedule, which you will see is jam-packed. And we also gave you the full schedule of the 2-day conference we just held here last week, the National Prisoners' Rights Advocates Conference. We had over 200 prisoners' rights lawyers and prisoner advocates who came for 2 days of panels and speakers and networking and community building. And in case you're interested, we included the very lengthy, we had 18 sessions, I think. We included the roster. And also I wanted to mention to you that if I know many of you are local, and if you're interested in finding out what we do, attending some of our events, I hope you will follow us. I wrote the Twitter at UCLA Prison Law is our Twitter handle, and thanks to some very tech-savvy law students, not me, we have an active presence on Twitter, so if you want to know what we're up to, you can follow us and also like us on Facebook. I'm supposed to say that. What else to tell you? So we're an initiative, the Prison Law and Policy Program is an initiative of the UCLA Epstein Program in Public Interest Law and Policy. And this makes sense because, as I just suggested, in 21st century United States, criminal justice reform, penal policy is very much at the heart of public interest work. We now have 16 affiliated faculty and a remarkable and sizable number of students, fabulous students, who are active in the program and who attend our events. And as it happens, we have a number of students right now who are very interested in the issue of bail reform, and several of them are working with one of our panelists, Margaret Dooley-Sammuli, on a court watch program in LA County to try to get some real-time data about how the bail system actually works. And the student organizers asked me to mention this in case there are any law students, UCLA law students here who are interested in volunteering to be a court watcher. They told me that even a few hours would be helpful. And if you're interested, you should contact Zach Heinzelman, and I've just put his email up here, Heinzelman2018@law, and that would be terrific. So, right, so as I just mentioned, we have, in addition to our active student membership, we have 16 affiliated faculty, and this deep bench actually I think makes us one of the strongest law schools in the country on criminal justice. I would say the strongest, but I'm trying to be modest, so I say one of the. And the deep commitment of the faculty is, I think, part of the reason that we've recently received some seed money from the main campus to start a new criminal justice program here at the law school, which we are excited about. We hope to grow it into a center. It's starting as a program, but we do have seed money, and we are starting to advertise for an executive director. So I mentioned that in case anybody here is interested or knows people who might be interested, let me know. I can send you the job description. And our inaugural faculty director is going to be Professor Maximo Langer, who couldn't be here today, but he asked me to send his regrets, and so I'm telling you about the project on his behalf. So in any case, so all of this, the program in public interest law, the prison law and policy program, the new criminal justice program, the 16 affiliated faculty, the active student body, all this I think should make clear why UCLA is really the right place to do this event on bail reform, and why we are so glad to be co-hosting it with Representative Lieu, who has put this important legislation forward. So some of you will know that Representative Lieu formerly served California as a state assemblyman and a senator. He was elected to Congress 2 years ago to represent California's 33rd district, which is the district we are in right now. UCLA is a big constituent of the district. Now, Representative Lieu was elected in 2014, you may remember, to replace our long-serving Congressman Henry Waxman. And I think it's clear that Ted Lieu is already a worthy heir to Henry Waxman, who was also a champion of progressive causes and a leader in Congress. So Representative Lieu just arrived. He was elected president of the Democratic freshman class by his colleagues. He's already distinguished himself as a progressive champion on a variety of issues: environmental protection, Social Security and Medicare, civil rights. You already heard about his work on Veterans Affairs. And as you know, he's taken a major role in fighting for badly needed criminal justice reform, most notably by introducing and actively sponsoring the No Money Bail Act of 2016, which we are here to talk about. So I'm proud that he's my congressman, and I'm pleased to welcome him here today, and I'm going to turn it over to Representative Lieu.
Thank you, Sharon, for your wonderful work in this area, for the introduction, and for all of you for being here. There are some folks I want to recognize who are here with us today. We've got Sherry Go from the office of Sheila Kuehl, as well as Kimberly Gilmont from the office of Mary Garcetti. And that's important because local jurisdictions can actually start reforming bail now. You don't really need an act of Congress to start doing it, and so hopefully we can start seeing some local folks go forward. I also want to thank the institutions that made today possible, UCLA, as well as the UCLA Law School, Brave New Films, and then my amazing staff. We have Lisa and Ashley and Wes, plus 3 interns here, Jared, Jordan, and Talha. And I want to know that Jared and Jordan are currently at UCLA undergrad. I love UCLA. I did my, as Sharon said, my swearing in here, and it's a fabulous institution. And then we've just been joined by someone working on the bail issue at the state level, State Senator Bob Hertzberg. Thanks so much for joining us. So I'm going to talk about how it is I came to introduce this bill, the status of it, and sort of how we go forward. So before Congress, I didn't walk around thinking about bail. And I can guarantee you most members of Congress do not think about bail. It's one reason I introduced this legislation, is to get people to start thinking about this issue. The reason that I even know about it is because one of my constituents came to my office and said, hey, look at this issue. There's some profound unfairness going on. And we looked at it and we thought, is it really true that there's 450,000 people sitting in jails and prisons that haven't been convicted of a single thing? And yes, that is true. And is it true that we're wasting all these resources housing these people that haven't been convicted of anything? And yes, that is true. And is it true that it's essentially criminalizing the poor? And I think the studies will show that. And so I introduced this legislation because Dorothy Wright, one of my constituents, she's here today, thank you for being here, brought this issue to me. I'm a veteran, former military prosecutor, and public safety is one of my top priorities, which is why I support bail reform. Because the current system is not rational. The current system makes this very strange linkage that says how dangerous you are depends partly on how much cash on hand you have. Right? That makes no sense. Other jurisdictions have looked at this, Washington, D.C., Kentucky, they've gone to a risk assessment system where basically they'll say, all right, we don't care if you're a millionaire. If we think you're dangerous, we're just not going to let you go. Or if we think you're going to flee because you have millions of dollars, we're not going to let you go. But if you're poor, or if you're reasonable means, or we don't actually care how much money you have or don't have, if you're not dangerous, we're going to let you go, unless we think you're going to flee. And when Washington, D.C. implemented this, it turns out that an overwhelming majority of people come back for the hearing. Kentucky, a red state, now is doing this. And in both jurisdictions, the reports I've read, they actually have less pretrial crime and a safer system, because it also forces judges to actually do a risk assessment, a real one, instead of relying on the crutch of money, right? Right now, they can sort of have a sliding scale where they'll go, I think this person's sort of dangerous, but I'm going to have this whopping bail amount and let them go. And to me, a system where you link money to both freedom as well as dangerousness is not only unfair, it's irrational, and it's not good for society. So that's the first reason that I'm interested in reforming this. But the second is, it's just fundamentally anti-American, right? We are basically criminalizing the poor. And in some jurisdictions, like Missouri, they've got local jurisdictions where even if you were to post bail and you come back for a hearing, you don't get your money back. It's just a straight payment to get out of jail. I don't even understand how that is constitutional. But essentially what we've said in places like that is we're going to make you pay some amount so you can leave even though you have not been convicted of a single thing. And to me, that violates the Constitution, violates our fundamental notion of innocent until proven guilty. And then the sort of last thing I want you to think about in terms of bail reform is other countries have in fact banned having money in bail. The U.S. and the Philippines are actually the two countries that now have the largest bail bonds industry. After we introduced this bill, Dog the Bounty Hunter and his wife came out to lobby against it. And if you sort of look at what's happening, right, how many super PACs do you know that are out there to help poor people who can't post bail? And how many lobbying firms exist to help poor people who can't pay enough money to get out of jail? And how many poor people actually can hire lobbyists to fix this issue? It's going to be zero. On the other end, you have this huge industry, right, is perpetuating a current status quo that is less safe and less efficient and less fair than the alternative system. And so hopefully we can get this changed. The bill, we introduced it. So frankly, in a presidential year, not much happens in Congress. But I'm very hopeful for next year. We have criminal justice reform where you've got Republicans and Democrats coming together on a whole variety of issues. To me, politics is sometimes like a circle, right? Sometimes you're so right, you're left, and vice versa. So you now have the NAACP and the Koch brothers on the same page on many of these issues. You have Republicans who are fiscally conservative, looking at the warehousing of people as simply a waste of money. You have libertarian Republicans who believe certain crimes you should not go to jail or prison for. And then you have Democrats who view it as a moral issue. Why are we criminalizing the poor? Why do we have this disproportionate number of Latinos and African Americans in jails and prisons? So I think it gets some real reform. And I introduced this bill because I want it as part of that larger criminal justice package that I believe will happen next year. And so look forward to working with all of you. And at the end of the day, if we could just raise awareness and get people to think about this, I think you'll get more and more people in the public to go, yeah, this system's not fair, we need to reform it. And by the way, this is being live streamed by UCLA, so whatever you say will be captured, just so you know. Thanks so much, and look forward to being on the panel.
Okay. So
Do I play back?
We're going to come up now and start the panel part of the program.
Okay, very good.
Yeah, so have a seat. Everyone join you. Take a minute for the panel to take their seats.
Just a reminder, if you have questions, just write them on your note card and put them to the side and we can collect them throughout the event.
So I'm still Sharon Dolovich. I'm going to be moderating today's panel. There are bios of the panelists should be at your seats, or else you pick them up at the front. So I won't spend a lot of time describing the accomplishments of these folks, but our panelists are Ingrid of A New Way of Life, Margaret Dooley-Sammuli from the ACLU of San Diego, and Congressman Lieu. So I'm actually going to ask Margaret to start, and I wonder if you could talk a little bit about the purpose of money bail and how it's supposed to work in practice.
It's a very old idea. So old it isn't good anymore. The idea was that you put up some money to ensure that you will return to court to face trial. What has happened is over the years, that's transformed into thinking both about your appearance at court and public safety in most instances. So judges are instructed to set money bail or other conditions of release that will ensure public safety and your return to court. This is a lot of judicial discretion, and so we have different judicial cultures around the country. So, and what we've seen is in the last 30 years or so, we went from releasing many people on their own recognizance or with low money bail to detaining more and more people pre-trial and bail amounts going up higher and higher. So I think, can't remember if someone mentioned this already, but the average bail amount or the median bail amount nationally is $10,000. In California, it's $50,000. And so far in our court watching, I don't know that we've seen any that low. For various reasons, it gets very high. And so we went from having a system to where people could put up the money or promise to pay the money if they didn't show up, to a system where now you need a private bail agent who you will pay about 10% of the cost of the bail, and if you appear at all of your court hearings, best case scenario, you will never get that money back. Worst case scenario is you're hounded for many years to pay them more. Bail companies rarely pay the court even when people abscond. They have done a wonderful job of influencing the laws, the regulatory laws around bail. They are backed by insurance companies, and we've been doing some investigation around the state, and we talked to one clerk who said she'd been there 13 years and never seen a payment from a bail bonds company. So this is a great, I don't want to encourage anyone to go into business, but this is a very lucrative business to be in, unfortunately, and it has, we can talk more maybe about public safety and appearance at court, but I think the Congress member mentioned this is what you all know, this has nothing to do with safety or with a fair system. So the system, people don't understand it works this way. When they find out it does, they're very confused and sort of flabbergasted that it could be so, well, people who are not stuck there or people who do not experience this all the time are really astounded that our system is really so fundamentally unfair. So we'll talk more about what we need to move to, but as you've heard, we have almost 500,000 people in jail. Many of them don't need to be there. And that's something that, it's really a rallying cry. That we haven't had such a sense of urgency before now is really kind of astounding, but I'm very glad that momentum is building now.
Okay, so thank you. So Ingrid, I know you have some personal experience with the system, and I know you work with people who have personal experience of the system, so I wonder if you could just give us a sense from the perspective of someone who's experiencing the system, how it works as a practical matter.
I'm sorry. Basically, in regards to bail, right?
Yeah.
Being able to bail out. You're arrested. If depending on if you're not on probation, if you're on probation, you have a bail or you have a hold. So if you're not on probation, you just have the bail. They set the bail, whatever they set the bail at, 50,000, 40,000. Mine was at 100,000 for a petty theft charge. And then you have to.
Did they give you a reason?
Why the bail is so
Yeah.
high? Of course not.
No. Okay.
No, of course not. They don't give you a reason. They just tell you this is what the bail amount is. If you want to bail out, you pay 10% of whatever it is. You try to look for, you know, a bail agent to be able to bail you out. And you have to do it before court, because if you don't do it before your first court date after you're arrested, they triple the bail or double the bail. So my bail was 100,000 when I got arrested. After court, it was 170,000 for a commercial burglary charge where the items was under $500.
And again, they didn't tell you why they increased it?
No.
No. And what's it like, where do you find a bail agent?
They have bail agents conveniently listed near the telephone that you're making the collect call from. And inside of the holding cells, and they even have people who are so conveniently outside of jail to pass you bail cards.
So people in the industry are sort of, obviously they're waiting for business.
Of course, yeah, it's lucrative.
Right, okay. I guess it goes without saying that if you don't have the money, you end up in jail.
No, if you don't have the money, you stay in jail.
Right, thank you, right, you stay
You
in
don't
jail.
get out.
Right,
You
right, you
stay
don't
there.
get out. If we're thinking about how we might change the system, we have to think about alternatives. And I guess, Margaret, I want to ask you if you can talk a little bit about what alternatives have been tried elsewhere, and you know what lessons we can learn from the experience about how we should go about fixing the problem.
Can I ask Ingrid a follow-up question?
Of course, please.
Because, you know, sometimes we stop the conversation at, you know, you can't get out, but, and, you know, this is a very public setting, so obviously you don't have to share anything you don't feel comfortable with, but you weren't able to get out. Is there anything you can say about what that meant for you and your family?
That meant that if you have a house, car, and kids, it's gone. If you're the only breadwinner in the home, that's what that means.
And you know, even a day or 2 days, if you don't have a driveway and you park your car on the street but you can't move it, you'll lose your car. So I mean, even hours of unnecessary detention can cause real harm. Right. So alternatives. You've heard about Washington, D.C. a little bit. So their system is a risk-based system. So the idea is that instead of basically your wealth determining whether or not you are released, the idea is that there would be an individual, there is in D.C., an individualized determination of your risk to public safety and likelihood to return to court, and also your needs in order to do those things, achieve those things. So for example, For many people, they need a phone call, like a reminder that the court date's coming up. And they'll do that in DC. We don't do that in California. Sometimes a bail agent will do it. There's nothing requiring them to. So you're on your own. You know, in a money-based system, you're really on your own to try and go through the court case. And I can't remember which county it was, but someone was telling me that this isn't just one court appearance. It might have been LA, because it's so backed up. One case, there was this gentleman had to show up 13 times, and it kept getting continued. And he missed once. So now he has a failure to appear on his record. You don't see 1 out of 13, you see 1. So, so moving to a risk-based system is better than money if we do it right. DC seems to have done a very good job. They have an 88% release rate. The vast majority of people come back to court on their own volition with a reminder. And they have a very low rate of rearrest while on pretrial, and an even lower rate of violence while people are on pretrial. Kentucky has a very similar system, but a different judicial culture. So they don't release as many people as Washington, D.C., and the feds are also supposed to have a system where money doesn't keep you detained. But they only release 33% of people, of pretrial defendants. So we have a lot of work to do to move toward a system where we're making rational choices, not just based on your risk or your likelihood to appear, but on what you need to achieve those things. Did you really flee the country? Is that why you missed your court date? Or did you miss the bus, or have childcare issues, or not realize that it was Tuesday instead of Wednesday? And so in DC, they've really set a good model for us. They've been doing it for a few decades. There's a lot to follow there to improve the system. California does have some counties that are doing this. What we're seeing, though, is that even counties like Santa Clara, where they have a good pretrial system, judges will feel more comfortable sort of reverting to the bail schedule, and that's where that number comes from. There is, every year, every county, judges get together and come up with a bail schedule. There's no guidelines, no consistency. The numbers only go, the money only goes up. I mean, we had a major recession in 2008. Bail amounts didn't go down. They continued to go up. And there's other ways to use the schedule to increase those amounts, but that's where the bail comes from. In San Diego, before Prop 47 reduced drug possession to a misdemeanor, possession, the bail for possession of methamphetamine was, I think, $10,000. In Tulare or something, it was $45,000. Anyway, sorry. All over the place, totally crazy. Moving to a risk-based system is better, but we have to be careful.
Okay, so Congressman Lieu, can you talk a little bit about why you decided that no money bail would be the right system?
Sure. I should probably say what the bill does, first of all.
Great.
So the bill does two primary things. First of all, it says to a federal system you can no longer use cash in your bail system. Feds are generally much better than the states already in terms of not doing this. And then it tells the states, you've got 3 years to transition to a new system, whether it's like DC or Kentucky. We give a lot of freedom for the states to decide how they want to transition and what system they want. They just can't use cash as a determinant for how dangerous you are, essentially, or have it determine whether you should be free or not free. So that's what the legislation does. Every day we're trying to get more co-authors to it, and it is our hope that next year we can get it into part of the larger criminal justice reform package, because I think when you start explaining the facts, both Democrats and Republicans are open to reforming the current system, because it is not efficient nor is it safe.
Right, so Margaret talked in her, talking about alternatives, about the way money still comes into it, even with these alternatives. So was there some particular reason that you decided that we were just going to get rid of them? Because somebody might have said, well, maybe we should reform it and reduce the role of money, but still keep it because it's a dramatic change from where we were before.
So we decided to take all money out of it because DC did it and it works pretty darn well. But also keep in mind, so judges right now are already going through in their minds a risk assessment, right? Because they already have to set a bail amount. They just have money as a crutch, where they don't have to think very much, right, about how dangerous this person is. They just sort of set a whoppingly high number, and then they go to the next case and so on. But they're already in their minds going through a risk assessment. So this is not going to be a major change. They just have to go through a better risk assessment.
And a more transparent one, presumably.
And a more transparent one, where they can't just sort of say, we'll just assess this huge bail amount, and if you're poor, too bad. And if you're rich, you get to leave. So it's not going to be a radical change in terms of how judges already are trained to make risk assessments.
Right. So I mean, there's a couple of ideas floating around. One is we're trying to get people to appear in court, which is the traditional purpose of bail. And then there's this other secondary purpose that sort of creeped into it and almost maybe now dominates, which is the public safety determination. And so there's two, Margaret, you talked about, I was going to ask, and you talked already about it, that how do we, somebody might say, how do we assure that somebody's going to show up if we don't have bail as a security? And so you talked about maybe, reminders or other, easy technology that we could use just to make sure that people appear. And Ingrid, I wanted to ask you, in your experience, what would make a difference to making sure that, you have a lot of clients at your organization. Do you have thoughts about what would make a difference to helping make sure that people show up for court, even if they're released?
Well, the thing is that an alternative to bail is your own recognizance. And that's what I was eventually released on.
Really?
Without a problem.
Mm-hmm. How did that happen after you were given?
I had to go to court about 4 to 5 times. So the thing is that should have been the first thing. And I came to court. And many other people come to court. So the fact of bail is like, who's being paid? Who's really making money off of it? And the OR system works. So it's not an alternative because it's already a system that's already put in place where they let people go and you promise that you're going to come back to court, and if you don't, you're going to go and be rearrested. So why doesn't that system just be the one that is used? Or when you're in prison, if you do good, they let you out on an ankle monitor and you do the rest of your time, and you're a state body. So the bail is when you're in county. The ankle monitor is when you're a state body, and of course you're in there on a charge that puts you in prison, and they let you go on an ankle monitor to make sure that you're gonna do your time, you're gonna do what you're supposed to do, and then you're removed off of it. So these things work. So if these things are working, then why do we have to question alternatives if we already have things that are already in place?
It's a great point. One worry I think about the ankle monitor is it's costly. And when you're on an ankle monitor,
it's free.
Well, that would be the idea. That would be the hope, I suppose. Well, I wanted to ask you, so, what I heard Margaret saying was that there are some strategies that jurisdictions are using to help people remember their court dates. And do you think that would be useful to have technology if you got phone calls, if you got text messages? Do you think that would make a difference to people?
Yes, it would.
So it's sort of like a plus and, right? We already have the system of your own recognizance, and then we could add to it some easy technological fixes that would.
A phone call would work. They could provide resources to where if you don't have the money to make it to court, they could provide you with bus fare. There's all types of alternatives that could be put in place.
Right. I think that's ways that where people you can ensure that the person returns back to court. Right. So I think that's really important, and that's one of the justifications for money bail. The other one, as I mentioned, as others have mentioned, is this public safety question. And I guess, Margaret, I wanted to ask you, so right now, we know that judges use the bail schedule as a way to detain people who they might, as Congressman said, in their head they're doing a risk assessment and they think, I don't want this person to get, I'm going to set the bail at at $5 million. And I guess I'm wondering, so some people might say, well, that's why we need a money bail system, so that we can keep people in custody who are public safety threats. So I guess I wanted to ask you if you could say a little bit about how the no money bail system would deal with this issue.
Sure. So, can I say one other thing?
Please, we can talk to each other.
So one thing I think that is important to mention that Ingrid was getting at, which is that bail is set very high and people can't get out. So the Bronx Freedom Fund, you may be familiar with, a bunch of public defenders in New York started this. They said, we'll pay bail. So they created a nonprofit and they bail people out of jail. Nobody has to pay them back. There are no, I think sometimes they provide some supports like calls, text message, but they don't track people. They don't do surveillance. And they have the vast majority of those people show up to court. What's really telling is that half of their case, so they compared, right? There's a comparison group that did not get out, they couldn't afford bail, and the group that they were able to bail out. Very similar populations. Of the group that stayed incarcerated, 96% pled out. They pled guilty to something. Of the folks that were released, 55% of their cases were dismissed. So what's happening is people plead guilty to get out.
Right.
That's it.
Right?
That explains the conviction statistic that the Quattrone Center identified, right? That more people who are in custody end up getting convicted, and that's probably why.
And they show up in court in an orange suit or whatever color,
Right.
and they get a longer sentence, a harsher sentence.
Right.
They plead guilty just to get out.
Right,
Right.
And they have a record.
right.
And what can be, a public defender was describing to me how on the one hand, the prosecutor is arguing for the highest bail possible, this person's really dangerous, we can't let him out. And then on the other hand, they're offering a plea deal, time served, right? So that's pretty transparent. I don't know how it can get more clear than that. So that's why it's so exciting to have UCLA students and other law students in courtrooms, because our statute's not bad. The practices in the courtroom are horrifying. Sorry, what was your question?
The question was about public safety and how would a money bail system,
Without a money bail.
without a money bail system, how would we ensure that people who are considered public safety threats are still kept in custody?
Right. So obviously this is going to be a very contentious, this is something we are trying to do bail reform in California, and this is a very important and nuanced question because risk, so for example, a risk assessment tool will evaluate 400 to 400, depending on the tool, factors about you and determine, sort of come up with this magic number to determine how dangerous are you, how risky are you to release. And some of these tools are terrible, some of them are better. Not one of them can undo the fact that every stage of the criminal justice system has racial bias. So even if you find race-neutral factors, you will have a situation where people of color, because they're over-policed and over-represented, will show up, will unfortunately be deemed riskier. But what I would say is, what we're really saying is, they're at higher risk of being rearrested. Sure, because they're over-policed. So, but in any case, I don't see a scenario in which through a risk assessment we can eliminate racial bias. However, we can't let perfect be the enemy of good. We need to make huge progress because consider where we are now. Where we are now is rampant and completely non-transparent pretrial detention based on very little information. Most judges, all they know is what you've been charged with. Mostly that's all they know. And so they're using, that's the information they have. They go to the bail schedule, there's a number there, maybe there's a few charges, they stack it, and that's it, they're done. They don't have information. So the idea is get the judges more information that is as objective as possible. Ensure the judges they need to be confident that we do have a well-funded pretrial services program that can provide a range of services to people who have been released. Everything from nothing, right, release on your own recognizance, to a text message or a phone call when it's your court date, to maybe something, on the other end of the spectrum, some more significant monitoring of some kind. So when judges feel confident that those services are available, they are more comfortable releasing individuals, in part because they no longer feel 100% accountable for this person. They share the accountability with, or they they say now the accountability is on this pretrial services agency, not on me, the elected judge. And so I think that does help to change the culture and think, okay, well, you know, I can't release this person with no support, but I can release this person with some support. So what we need is a transparent tool that all of us have confidence in, that we can independently verify. Then we need well-funded pretrial services. This is not a cost-saving measure, really. I mean, we free up jail beds, which is huge, but we can't skimp on pretrial services, or I think we run the risk of not decreasing our pretrial population as much as we should.
So, Congressman Lieu, do you have any thoughts on the public safety, like sort of what would come next after this bill, or are you just focused on the no money bill part?
Sure. I'll give you two thoughts that sort of explain why this is so irrational. If you look at the population of people that can't post bail, they're exactly people that can't buy a plane ticket to Hong Kong, right, like Edward Snowden did. They don't have the resources to flee in a way that someone who actually could post bail can have the resources to flee. So you have this strange system where you're putting exactly the wrong people in pretrial detention. And then second, we already have an entire system based on your own recognizance, right? It's called probation. And in probation, you are on probation because you've actually been convicted of a crime. And you may have served some time or not, but you have been convicted of a crime. And then we give you probation, and we expect you to do a whole series of things, like come back and meet with your probation officer, you know, once a month. And you can't do this, you can't do that. And society is fine with that. And somehow, that your own recognizance concept, when it comes to pretrial detention, it gets flipped. Because you have this person who hasn't even been convicted of anything, and we think there's massive danger to society. When we treat someone on probation who actually has been convicted of a crime differently. So just in terms of public safety, this just doesn't make very much sense. It would just be a much safer system if you just did a straight risk assessment and then release people who are not dangerous and kept in jail those who are dangerous regardless of how much cash on hand they have.
Thank you. So we're going to come to questions shortly, and if you have questions, please write them on the cards and they'll be picked up. And we still have a few minutes though where I want to ask a few more questions of the panel. So I want to move to thinking about the bill and what it would mean and sort of challenges to its passage. So the first thing I'm curious about are the stakeholder reactions, how the bill has been received. And Ingrid, I wanted to start with you. Do you have any sense of what it would mean for the people you worked with if this bill were to pass and the money bail system were to be eliminated?
This would mean that families are not ripped apart. You know, people make mistakes, and I feel like the bail system kind of uses the fact that once you're in jail, you want to do anything to get out. So you're going to figure out a way to come up with some money so that you can come home, and they capitalize off of this. So this would mean that these bail people or these bail companies no longer get to capitalize off someone being ripped from their family because of a mistake that they made. That they could, you know, they could trust the fact that, okay, yeah, I made this mistake, but I'm going to make sure that I go to every court date so that I could rectify the mistake that I made and not feel held accountable. We're already, a lot of us that are in jail are already come from a low income background. So it's hard trying to come home and you're already in a low income bracket and you're trying to scrounge up money to keep paying a bail person and to try to stay afloat. And then you want us to come to court and do this, and it's a strain. So at the end of the day, this would mean that those strains are no longer placed on us. That, you know, humans make mistakes. And it just brings back the human aspect, that just treat that person according to the, you know, whatever mistake that they made, and just trust that they're going to come back. And if they don't, then of course policies and laws will be, you know, put in place so that you can ensure that if they don't do what they're supposed to do, that they'll be held accountable. And that's just what it is in life, period.
Can I just add something real quick?
Yes,
So first of all, thank you, Ingrid, for being here and your courage and for sharing your story. We all really appreciate it. And so what you said was very interesting to me. So it's true, we all make mistakes. And in Ingrid's case, when she made a mistake, her freedom was deprived. But the same person in Ingrid's case who was rich and had cash on hand, his or her freedom would not have been deprived.
Exactly.
I mean, that's how fundamentally unfair, right, the current bail system is.
I was also going to thank you for just helping us think about the experience from the perspective of the person who's going through it, which I think sort of reminds us why the bill is so important. I was actually going to ask you, Congressman, about how the bill has been received from the various stakeholders from where you sit. What kind of reactions have you gotten? Who have been the supporters, the opponents?
So we've had tremendous support from numerous civil rights organizations. So the NAACP supports it. We've had a lot of different academics support it at our press conference announcing the bill. We had various academics there in support. And I just want to say it was announced with 4 original co-sponsors. It was me, Representative Ruben Gallego out of Arizona, Representative Bonnie Watson-Coleman out of New Jersey, and Representative Brenda Lawrence out of Michigan. And since then, we've added a lot more co-sponsors, so I think it's getting more and more momentum. And we have Brave New Films, this amazing company that makes documentaries, now doing a documentary on bail that they're going to release next year. We have more and more media publications writing about it. We have this seminar, I think, so we're getting more and more awareness. The U.S. Department of Justice recently filed a brief in federal court saying, you know, the current bail system in some jurisdictions is unconstitutional. So I think we're getting movement and just raising awareness, right? Just getting people to think about this issue, I think is helpful.
Yeah, and actually one of the questions was how can we, besides educating each other, how can stakeholders take more direct action? So you're talking about, we have this step, which is education and legislation. Then there was a question that we'll come to about what else we can do. Before we get there, I wonder if you could talk a little bit about who's been opposing the bill and what are the strongest, sometimes the strongest substantive objections don't come from the strongest opponents. So I'm curious to know who the strongest opponents have been and what you think the strongest substantive arguments have been.
Well, so the bail industry opposes this bail, reform bill, and I don't have anything against the people in the industry. They're good people. I think the system is bad. Now, I think the main argument would be it is less safe because you're releasing someone without sort of this money thing here, and so they might not come back to court. Or they might go commit a violent crime, which is a little strange, right? That, you know, that linkage is, I don't get that linkage. But I do understand the linkage of, you know, some people argue, well, if you don't have this whopping amount of money there, they might just not come back. Well, when you sort of think about the people that, you know, can't post bail, they're not likely to flee anywhere because they probably have a low-paying job that they're barely making it by, helping their kids, and they don't want to lose their car payment. So there's a whole bunch of reasons why they're just not going to get up and flee because they don't have the capability or resources to. And when you see other jurisdictions do it, it's just a massive counterexample that shows, well, actually, when you implement the system, people do come back.
Right. And what do you think, I think people in the room are probably curious to know what you think about the prospects for passage. I know it's an election year, so as you said, they put the legislation aside. But maybe you could talk a little bit about what you see coming.
So there is more and more movement for overall criminal justice reform. It is not going to happen this year, but I do believe it will happen next year. It's just what will that be? And regardless of what it will be, I would like to get bail reform as part of that package. So I think that's what we're aiming for legislatively.
Do you think that's possible? I mean, do you see that as likely or a long shot, or how would you?
No, I think it's absolutely possible. Because some of the things that are about criminal justice reform, I think would actually have a far more larger impact on people's views of public safety. You know, bail reform, if you do it, it's not, compared to some of the other things folks are talking about, I think it's not as controversial. That's sort of my
so you think it's not as much of a hot button, so it might have a better chance of getting.
Once you explain it, right? Because people don't think about it. They probably don't even know how the current bail system works in many cases. But the other reason that we introduced the bill and we're trying to raise awareness is, right, Congress, I like to say, works at a majestic pace. So it just takes us a long time sometimes. But local jurisdictions can just start doing it, right? And that's what's so exciting to me. If we could get county supervisors to go, you know, this system isn't working that great. Let's just change it. Or states, right? Like, you know, what the work state Senator Bob Hertzberg's, the work that Senator Bob Hertzberg is working on in terms of bail reform. You can get states to start making modifications. So they don't have to wait for Congress. They can just start doing some of these things now.
So speaking of states and responding to the bill itself, you mentioned that in the bill there are pressures on the states to adopt the no money bail system, but we know that Congress can't force the states to do anything. So I wonder if you could just give us a little sense about how, if the bill does pass, what it would mean for states and what kinds of pressures it would put on them?
Well, so it would be a clear signal, right, from the federal government saying, hey, the current bail system is unfair, unsafe, and likely unconstitutional. And you states better come up with a new system where you're going to start losing money for your law enforcement. So I think it gives, first of all, gives states cover to start doing this, right? It gives their elected officials the ability to say, well, I don't know what I really think of this, but I'm going to support this because Congress is telling us to do it, and they're going to cut off grants.
How big is the cutoff, the grant cutoff, if they don't comply?
I'll get you the exact number, and it varies. But I'll get you the exact numbers, and it varies by state too.
Oh, I see.
Yeah.
Okay.
So
Right.
we'll get that to you.
Yeah. And Margaret, from where you sit, last question, because I've been told I'm going to move to Q&A in a moment, but I wanted to ask you this one last question. From where you sit, is it possible to say, is it like, I know you work mostly in California, do you think it's likely that states will respond? What do you think the impact of the bill would be on the ground if it were to become law?
Well, I think, as the Congressman said, there really is a moment here, not just with bail reform, but more generally criminal justice reform. I think increasingly including bail reform. So I'm hopeful that we will see interest in bail reform moving from state to state. DC did it a long time ago, Kentucky. New Jersey will implement their new system in January. And I hope that, given what a large state California is and our role as leader, that we can be successful here in reforming our own system so that we can, contribute to that momentum nationally.
Okay, thank you. So I have a few questions, and I think I'll add.
Sorry, there's another stack.
Oh, there's another stack. Okay, we have many questions. Okay, this is actually about the nuts and bolts of it, and I think it would be helpful. So the question is, where does the money go? If the bail is paid and it's kept, how is money bail related to the broader issue? So it sounds like you've told us that the bail money kind of disappears. We have a notion that it goes to the court, but actually doesn't end up getting paid to the court. So is there a relationship between money bail, how it's working, and the broader issue of underfunded courts, court fees, etc.? So really, is reform possible without also reforming the courts? Is there a relationship here?
So in California, courts don't get money from bail. So who makes money are bail bond companies that will provide you the service at a charge of 10%. They don't put any money up front. They will promise that if you don't appear, that they will pay. On the back end of that, the conditions around the circumstances in which they would actually be required to pay are such that they are not required to pay, and it's up to the court to request it. So this doesn't happen, basically. I can say it doesn't happen very often. We're working on finding out how much it does. So the courts are already not getting any money from this system. Private industry is. So our the question about how should our courts be funded, I think is actually this goes to this broader question of fines and fees that people have been talking about. And do taxpayers pay for criminal justice services, or do we have defendants and people who are convicted pay for all of these, for the function of this service? So that's that broader question. But it's what we really do need money for in this shift is pretrial services. So that is what we need to think. That is a budget ask, and that's something that, you know, if you care about something, you pay for it. So that's what we're going to need to do.
So it's important to recognize that if you take money out of the bail system, it doesn't mean that somehow we're going to be saving the state any money. We're actually going to have to put more money in to try to deal with the issues that we're sidestepping now.
Well, you won't be you should be housing far fewer people in jails at a cost of well over $100 a night. You know, if we do this well, we should have empty jail beds. So we should have savings there that would be, you know, theoretically could be transferred to pretrial services. How it actually works is a little bit more complicated than that, but that, you know, so you would have savings from unnecessary and detrimental incarceration that you can invest in pretrial services, while you're also avoiding lots of harm, like not just incarcerating poor people, but actively keeping them poor.
So Representative Lieu, I have a question for you. So I'll just read it to you. It says, you question the constitutionality of money bail. One reason constitutional claims regarding bail and many other issues are not litigated is due to the chronic underfunding of the right to counsel. So this is sort of extending criminal justice reform beyond the bail issue. So the question is whether you and others have considered the need to support full funding of indigent defense as part of a package of criminal justice reform.
I have. I don't know in the package whether they will be included or not. I think it also depends on what happens in November, what the makeup of Congress looks like. And I'm not trying to be partisan, I'm just going to be descriptive. So the Republican-controlled Budget Committee on which I sit just has a very different view, where they want to cut funding to various programs across America.
So it's interesting because you talk about a bipartisan interest in criminal justice reform, but meaningful criminal justice reform will require investment. So if we're trying to cut back, that will cut against the possibility of...
So I think a bipartisan criminal justice reform package will have offsets. So if there's a cost for X, they will try to find an offset somewhere else. Now, freeing up jail and prison beds will be an offset, right? And so that, I believe their ultimate reform, in my sense, won't cost a lot of money because it won't pass if it does. But within that, you can be pretty creative in how you offset various things. And you could actually invest quite a lot in certain areas as long as you find a budgetary offset elsewhere.
Yeah, that's helpful. Yeah. That's helpful. So I'm just going to read this question. Isn't it true that fugitive recovery agents like Dog the Bounty Hunter save taxpayers money by taking this task away from the police, who have more to worry about than people who fail to appear? So it's a question about are people who do this work actually serving an important public function? So Ingrid, you seem to have a view, and I'd like to hear it.
Absolutely not.
That's right.
Can you say a little bit about it?
They don't save taxpayers money at all. They're on TV, it's a dog and pony show, and they're using my people as a way to capitalize and get ratings and show that it dehumanizes us, and it shows that they need people like them to capture people like us because we're criminals and convicts and this, that, and the other, when they bleed just like we do. But it's, no, it does not, it's not very helpful, and no, it's not cost saving, and no, they don't save the day, and the police do the exact same thing. It's just, you know, it's just something that they can capitalize off of.
No, anybody else want to comment on this?
I would just add that I'm not sure how many, first of all, most people don't miss their court date, right? We've already established that. Whether there's money involved or not, most people are showing up. So what about the few that don't? There are bounty hunters out there, but my understanding is that it's actually law enforcement that are making the arrests in most instances. So we are paying for that to find people. We are, because they are arrested by public agents. So the line's a little bit flippant, but what I've been saying about private bail in California is that we're getting exactly what we pay for, which is nothing.
So it's important, I mean, so if the heart of the question is, aren't they performing an important public service? The answer is no, because the
No.
police are performing it anyway. And it sounds like from what you're saying, they're actually doing harm.
Yes.
So a different question, I have many, from many different perspectives, so I want to get a number of these on the table. So this is an interesting question that relates to where the money goes and the role of judges. So why do judges continually raise bail rates here in California if the bail money companies keep most of the money? What do they think they're doing, and when they have a bail schedule, if in fact the court isn't getting any of the money they think they're getting? Congressman Lieu, did you want to?
Because, I'm speculating, I'm not a judge, but my sense is if a judge can say, hey, I made this defendant post this whopping amount of bail, so it's not my fault when that defendant who posted the bail goes and does something violent, right? It sort of takes responsibility away from the judge. The judge can say, hey, I did what I was supposed to do. I had this huge whopping amount of bail, and it's not my fault the guy was rich. But if you made them do a risk assessment, right, they would be, they'd feel a lot more responsible, because then they know, okay, I am releasing someone, and the public might go, why did you release that person?
Although wouldn't they then feel more pressure not to do the assessment and find that they were dangerous just on the off chance?
They might, right? So Kentucky has a sort of a different statistic than Washington, D.C. But it's not that you can't, but Kentucky's still a better system, right? And so anything would be better than the current system, in my view.
Ingrid, do you have thoughts on the bail schedule question? It looked like you might.
No.
No? Okay.
I'll just add one speculation, which is that judges also know that people post 10% to a bail agent to be released. So that could very easily lead to inflation of bail amounts. So a $50,000 bail in their mind is actually $5,000. So I think that's in part may contribute to it continuing to go up.
Got it. So the 10% thing is just the judge actually has that in their mind when they set bail. They're not even really thinking about the full bail amount.
Probably walking into this room, anybody that's seen Law and Order, you know it's 10%, right? People just know that.
Right. So speaking of risk assessments, which Representative Lieu mentioned, and we have a couple of questions about risk assessments, which I think are really, this is, as you already suggested, Margaret, this is a really tricky point, because it's not as if we were to implement a no-money bail system, the problems would disappear. We would just have to refocus our efforts to deal with other challenging problems. So a couple of different questions. How does, we'd still leave discretion in the hands of judges, which Representative Lieu just mentioned. And so the question is, how would this reform system avoid bias or prejudice? And how do we avoid risk assessments that identify mental health diagnoses as a risk? So how do we construct a risk assessment tool that would not have bias, that would not use people's mental health diagnosis against them, but would still be effective? And I don't know that we can have a clear answer to this question. This is a tricky one, though. This is tricky. So I'm interested in any response from anybody on the panel.
Well, so I agree with Margaret. This will cost money, right, to implement a risk assessment system. They'll be offset with their jail beds and so on. They're free, but. So I'll give you an example. I agree with Margaret that says, look, you've got bias everywhere, right? Not just in pretrial detention, which is why the U.S. Department of Justice earlier this year, Attorney General Lynch actually gave an order saying we are going to do implicit bias training for our prosecutors, our FBI agents, because there was a recognition there, right, that you do have bias in different levels. So you're just going to have to spend money training judges, right, to be able to use a risk assessment tool and to try to not have as much bias in there. But they're already, already sort of making this risk assessment determination anyways. But there will be money, you do have some money to train people to be aware of how to use the assessment correctly.
But of course, part of the problem is the construction of the assessment itself, right? And so even if we train them, maybe part of the challenge is how do we construct a tool, an instrument that would kind of identify the factors that we think ought to be identified and not allow bias to creep in. And I don't know if you have thoughts about that, or Margaret, yeah.
Yeah, so, you know, so I think this is one of the fundamental questions that states and counties are going to need to figure out. How do you, as much as possible, mitigate these racial disparities and other disparities in the system? So we know that certain factors will lead to racial bias, things like, you know, where you live, or you know, employment status or residence status. You know, those are things that we know will increase bias. There are more neutral seeming factors so we clearly want to avoid the things that we already know are not helpful and are harmful. And then the question will be, how can we not take away judicial discretion, but guide them now right now they have wide open discretion, and you know, we have high pretrial detention. So how can we direct them to go through a more thoughtful and objective process, and have to write on the record, maybe, you know, why they're making the choices they're making, for example, to deviate from what a risk assessment is telling them. If we can, you know, so we do have to think about what kinds of what kind of parameters do we set around a risk assessment, and we have to think about the fact that judges can override risk assessments. So we have to have the training and the culture change. I think we need public accountability. We need expectations to be, it's not acceptable to detain 60% of people pre-trial. So we need both, you know, the systems to be contained and have in them an intention and systems and accountability to address racial disparity. And we also need to address the cultural issues around the fact that you know, judges are going to have an implicit bias that people of color are more dangerous.
So a couple of things that come to mind as you're talking. One of them is, do you think it's possible, and this goes back to the accountability point that Congressman Lieu put on the table, do you think it's possible that if there were a risk assessment instrument that were developed, and in the thoughtful ways that you're describing, that judges might feel, it might mitigate some of the feeling of responsibility, because they could say, well, I did the risk assessment, and this is how it came out. This person, it told me this person was safe to release. So do you think it would have that positive benefit? Or do you think, I mean, you know, I guess judges all are.
Right. Yeah.
Yeah.
No, I do. I'd rather have them use that crutch, right, than money, right? It's just going to be fairer. But so I support risk assessments, right? And I think probably all do. But I just want you to think about, again, how odd it is that we do all this for someone who hasn't been convicted of anything.
Right.
But let's think about probation again, right? You've been convicted. You've been convicted of a crime, but we don't make you post money to leave prison or jail. Mm-hmm. Right? We don't make you post money and say, if you don't come back to see your probation officer, we take that money and keep it. Even though you are likely probably more dangerous because you haven't been convicted of a crime versus someone who has been convicted of anything. And we don't do a whole risk assessment, right? People leaving jails and prisons, we don't go through a whole risk assessment and go, okay, we're going to make you post this amount of money before you leave prison. So it's just very odd to me, right, that we have this bizarre focus on pretrial folks that haven't been convicted of anything, and yet for those that have been convicted of a crime, we're like, oh, just go on your own autonomous.
Okay, I'm going to ask you kind of maybe a shocking question. Do you think that we should take public safety determinations out of the pretrial determination? Because the original idea of bail had nothing to do with public safety assessments. It was all about, can you show up for trial? So one view is, this has creeped in for no legitimate reason. These are people who are only charged, not convicted, presumption of innocence, and the only question that the state should be asking pre-trial is, can we be confident that they will show up when we decide whether or not they were guilty of the crime? So I thought maybe it's a little radical because we've moved in that direction, but would any of you, I mean, what do you think about that as a response?
I'm not that radical.
Okay. Recognize that it is. Margaret?
I think you know, I think ideologically, we can have a real debate about that. I think practically and politically, we're not walking away from public safety. It's also in the California state constitution now, for example, through Marcy's law. So it's there.
Okay. Ingrid, do you have thoughts about the legitimacy, the purpose of deciding someone's public safety threat in advance of conviction?
I just feel like this. If you have the money to get out of jail, whether you're mentally ill, whether you have one leg or one eye, you go free. Period, point blank. If you don't have the money, they don't go through a risk assessment if you have the money to get out. So why do you need to go through a risk assessment to just let somebody go home? And if they don't return to court, then you take whatever steps you need to make sure that this person gets apprehended, or to make sure to figure out why they didn't come to court. I feel like the risk assessment, it shouldn't even be a conversation.
Fair enough. So I just want to put one last question on the table that I already alluded to, which is about kind of broader steps for change. So besides educating each other, and also besides lobbying for the bill, how do you think stakeholders could take more direct action to try to push for reform? Margaret, your thoughts?
Yeah.
Let's hear them.
So I direct the ACLU of California's Criminal Justice and Drug Policy team. I'm based in San Diego. We have staff around the state, and we are working with Californians for Safety and Justice, Ella Baker Center, many other groups to move bail reform in California. So please join us. And you can either join the court watching team, you can help with research, I know we have some organizers in the room, so we need all of you and your help.
Congressman.
I think it's really cool what those public defenders in New York did, where they set up a bail fund to just help people who can't post bail,
Yeah.
post it, and be great if more people thought to do that. We have a lot of wealth here in California, and maybe some folks might be interested, and that would be really cool if that could get started here as well.
Right. And as you mentioned already, that the states don't have to wait for the feds to act, so state political action is effective, should be effective too. Did you want to add something?
I just want to say, if anyone is interested in starting a charitable bail fund, I would like to talk to you.
All right, well, we are just about out of time, so I just want to really thank the panelists. There's so much more. I have many more questions that I wish I could have put to you, and thank you all. I'm sorry for the people who asked questions I wasn't able to get to. But this is really such an important issue, so Congressman, thank you for being a leader in this issue, and Margaret and Ingrid for your work, and thank you all for being here, and we'll just end it.